Verdict, Rev. Mr. Ashton. These next two witnesses.
Yes, sir. This reference to FBI agent Nickolas Savage and evidence control unit, not analyst, but officer Erin Martin. They're both sitting out there. As to our information, they have no firsthand knowledge of anything. Everything they know is what they were told. So we just request that there be a proffer so that we have a more orderly presentation to the jury and won't be jumping up objecting every 5 minutes. And if their testimony is not admissible, then they can go about their business and go home.
Mr. Mason, will you be conducting the direct of those individuals? Let me hear what they have to say.
Don't know.
Free run of what we're going to do, so they can have a night. How we going to do whatever you want.
Well, they claim I have no reason. I don't know what they're going to testify to. Their state claims it's hearsay. I have no idea what they're going to testify to.
The difficulty of, I'll clarify for Mr. Mason, if you like. The only thing that Erin Martin does for the FBI is take in evidence packaged by other people and send it to different parts of the FBI crime laboratory. She doesn't do analysis. She doesn't examine anything. So I can but assume that the defense is going to try to get into some aspect of what she was told by someone, since she has absolutely no firsthand knowledge of anything. And so that's why I requested the proffer, because I do believe that my knowledge of her is accurate, and I would ask counsel to proffer what testimony will be.
It's an interesting process that I need to tell them in advance what's coming. Nick Savage is an FBI agent that we have brought to testify about certain activities that he did at the request of the prosecution. And also that Miss Erin Martin from the FBI would testify about what she did in that response. So I'm not talking about one saying what somebody else did. I'm bringing the witnesses that did it.
Judge, and again, there's a question of the relevance of that, because we've already had one experience with counsel trying to get into whether an FBI agent asked somebody to do a paternity test. And the court already ruled that that fact was not relevant, that what the officer asked was not relevant, that what the analyst did was. My concern is that we're going back there again. And I just thought it would be a more orderly presentation if we addressed it outside the presence of the jury. And if the court deems it's admissible, fine. If it deems it's not, then we haven't wasted time jumping up and down and running to the sidebar. That's my suggestion.
Your Honor, it would appear to me that when an FBI agent has memorialized in an email words to the effect, when they're asked about photographs, to construct, in short version and proffer, create a murder weapon with tape, and they respond, "We'll just tell them we didn't take the pictures." That's pretty relevant to me, to the entire integrity of this case. I'll be happy to show you the emails now, if you wish.
The integrity of this case isn't on trial. The facts are on trial. The bias and credibility of individual witnesses who have testified is on trial, but the integrity of whatever it is isn't on trial, which is why I requested a proffer. And I would just ask the witness be called, it be proffered, the court can make an intelligent, informed ruling.
What is your pleasure, Your Honor?
I like to hear it.
You want to hear it now?
I can hear it now. You can hear it 8:30 in the morning, but we're going to start testimony at 9.
Well, let's go for it right now.
Okay.
FBI agent Nick Savage.
Nickolas, Nickolas, middle initial B, Savage, Savage.
You may proceed, Mr. Mason.
You tell us your name, please, sir.
Yes, sir, Nickolas Savage.
Mr. Savage, are you the lead FBI agent in connection with the investigation in the state of Florida versus Caylee Anthony?
I was during my time when I was actually assigned to the Tampa division and the Orlando resident agency.
In general, on the short version, what was your role?
I was the Crimes Against Children coordinator. I was also the Innocent Images case agent, as well as the National Center for the Analysis of Violent Crime coordinator.
Do you recall, sir, whether or not in February of 2009 you attended a meeting with various members of the prosecution team?
I recall being in a meeting where prosecutors were present, yes.
Do you remember a discussion regarding whether or not it's possible that duct tape could have covered the mouth and nose of this child?
Objection, work product. Discussion with the prosecutors or work product.
Mr. Mason? Objection, work product.
I guess it could be. That's a shame. Yes, sir. Okay.
Be sustained under work product.
As a result of your attendance to the meeting, sir, what, if anything, did you do?
Could you be more specific as to what meeting we're referring to?
Pardon?
Could you be more specific as to which meeting you're referring to?
The meeting, well, that we can't identify now. Meeting with the prosecution's team, sir, did you thereafter solicit and try to find some photographs for them?
Yes.
And what, if anything, did you do in order to find those photographs for the prosecution?
I would have coordinated with Karen Cowan, who had day in and day out contact with the lab.
Did you make a specific request for pictures that may have been taken by the Orange County Medical Examiner's Office, specifically photos with scales?
There were questions. Could you repeat the question, please?
Did you make a specific request to locate photographs that may have been taken by the medical examiner's office here?
Possibly, yes.
You remember, sir, requesting of Karen Lowe or Erin Martin, either of them, for the photographs that should have been taken, showing scale sizes of the duct tape?
There was a request made to the lab, yes.
And do you recall the reason that you asked for that duct tape, those photographs, sir?
I asked for them because I didn't believe that those photographs had been taken up until that point.
Did you receive a responding email from Erin P. Martin of the FBI?
I don't believe so.
May I approach the witness, Your Honor?
You may.
I want to show you what has been marked.
Just counsel will look at the two. This witness is not in the two line on the email. Karen Lowe, Brian Carroll, Elizabeth Fontaine.
Yeah.
Reflect Nickolas Savage, this witness.
I'm going to ask him if he's seen the email and identified. That's why I've got Erin Martin here.
Go ahead.
Thank you. I'll show you what's been marked, sir. If DL identification asks if you recognize it.
I recognize it, yes.
Did you receive a copy of this yourself?
The first time I had seen it when it was shown by members from your office. I hadn't seen it prior to that.
And do you recall the circumstances? In other words, does this refresh your recollection of the transaction?
Can I see it again, please?
Take your time.
I don't believe the witness has indicated any failure of recollection that needs to be refreshed, so I would object to that.
Overruled. This is a proffer.
Oh, yes, sir.
This is the first time I've seen this email. This is not the one that I looked at earlier.
I'm so close to you, I can't hear you. What did you say?
That is the first time that I've seen that email.
That's all the questions I need of this witness for this proffer, Your Honor.
I don't know if the court wants me to address the admissibility issues now. I don't have any questions for the witness. I don't know what counsel thinks is admissible in that, but I guess I'll wait till maybe after he argues, I'll call the witness back if I need to, but not seeing it.
Well, I'm going to ask Erin Martin to come in for the proffer.
Okay. The agent may stand down.
Thank you.
Chairman Martin. Yeah. Tell us your name, please, ma'am.
It's Erin Martin, ErinMartin.
How are you employed, ma'am?
I am a request coordinator with the Federal Bureau of Investigations Laboratory.
Do you have recollection regarding the date of February the 6th, 2009, sending an email to Karen Lowe by chance?
Not to my recall, no.
I'm wondering how magnificent I approach the bench, Your Honor, to show her.
You may.
And for the record, this is identification exhibit DM. Take a look at that. Tell us
Thank you.
if you recall that, ma'am.
Yes,
Would you read it for the court, ma'am, what you sent?
Hey Karen, I decided not to give the measurements to Nick that Brian emailed us. I'm sorry,
Ma'am, slow it down so the court reporter can take it down.
of course. Hey Karen, I decided not to give the measurements to Nick that Brian emailed us since it is part of your case notes and it doesn't appear that the JPEGs were saved. I didn't want to overstep my bounds when it comes to the case notes. I'll just tell Nick that LPOU had no photographs and that TEU has some info on the tape and to discuss it with you. I don't understand why the ME's office didn't take any scaled photos of the tape when it was on the skull. EPM.
And you sent that to Miss Karen Lowe, the FBI.
Correct.
And who is Nick you're referring to?
Special Agent Nick Savage?
The gentleman just walk out past you?
Yes.
And what does LPOU mean?
Latent Print Operations Unit?
And what does TEU mean?
Trace Evidence Unit?
Do you have any other involvement in that process than what you just said in that, read in that email?
I'm sorry, could you
Do
rephrase?
you have any other involvement in that process other than what you just read in the email you sent back?
In the case?
In this part of the case?
This part of it? No, not with the tape, no.
All right, sir. That's all I have from that witness. Thank you.
Nothing subject to hearing what the argument is.
Okay.
Recalling her, but at this point, no. would be both relevance and hearsay. And the relevance I don't see, but I'm sure counsel will suggest something and I'll argue, but clearly.
Let's take up Mr. Savage first as to the state's objection and the 9401 relevancy. What does Mr. Savage's testimony tend to prove or disprove dealing with a material fact?
A material fact in this case is whether there is or is not, as an example, a murder weapon. Mr. Ashton has tried to create the existence of one by saying that he had a theory that the tape could be a murder weapon and made a specific request to try to get photographs to prove his theory rather than get the evidence and see what it proves itself. And he's asked for those photographs, and he asked Nick Savage, who coordinates it, because all the evidence was sent to the FBI crime lab, and to find it and see if there were photographs with scales on it to show the actual scales measurements as related to the skull, supposedly taken by the medical examiner's office. We've heard conflicting testimony about that. The response he gets back is, in salient points, we'll just say we don't have the pictures. To me, that's pretty outlandish. And, you know, it occurs to me that it's not simply a matter of hiding behind work product, but whether or not it should have been and was in fact produced to us by the base stamp they're on as potential Brady material, Brady versus Maryland. It's trying to create something, and that's the evidence that catches them trying to create it.
So relevance is an attack upon the prosecution, an allegation that the prosecution has done something wrong.
Not
Even if,
I'm sorry.
that's okay. Even if that were true, still wouldn't be admissible because attacks upon counsel are specifically prohibited. I do think that if counsel will read the email more carefully, he will see that this is an attorney in a case, and I appreciate the fact that he thinks that I'm the one that thought of this, and I wasn't, but appreciate the compliment, trying to pursue what evidence is available. I'm hard-pressed to see what counsel would object to that. It would seem that any good attorney representing a client would attempt to explore available information to prove a material fact in a case, but be that as it may, it clearly is not relevant to a material fact in this case, and therefore should be entirely excluded.
Anything else, Mr. Mason?
The prosecutor would like to know if any of you had taken pictures, parenthetic, with scale in parenthetic, of the tape as it was received to show the full length and width of tape pieces before they were separated. They are ESP interested in the width info. They want to know if it would be possible for the tape as it was to cover both the mouth and nose areas. They would need the measurements photos with scale in order to do some computerized recreation images of the skull with tape. The ME's office only took initial photos of tape on the skull without scale, and they didn't measure it because they thought the full measures would be done by us. Would you guys review your notes and give Nick a call on his cell phone with his number? Thanks. Karen will probably speak with you when you're back about requesting some exams of on F's in the trunk area. And then the response is from the FBI on this very important matter. I decided not to give the measurements to Nick that Brian emailed us, etc. You have that in front of you. No, it's not a matter of attacking a prosecutor. It's a matter of attacking apparently the whole system.
Okay.
We have someone trying to create something that's not there and then saying, I'll just tell Nick that LPOU had no photographs and TEU has some info on the tape and to discuss with you. I don't understand why the ME's office didn't take any scale photos of the tape when it was on the skull.
Florida Statute 90.41 defines relevant evidence. It is defined as evidence tending to prove or disprove a material fact. The defendant in this case, Caylee Marie Anthony, has been charged with a 7-count indictment accusing of the crimes of murder in the first degree, aggravated child abuse, aggravated manslaughter, and 4 counts of providing false information to a law enforcement officer. The court, after hearing the testimony of Mr. Savage, finds that that testimony does not go to proving any material issue in fact dealing with the 7 counts of the indictment, nor does it go to impeachment on any relevant or material issues. Assuming for the moment this evidence was evidence of an attempt to fabricate evidence, then that would be the subject of a motion to dismiss based upon prosecutorial misconduct, which there is no evidence of that. But assuming you could stretch your imagination to go that far, that would be the subject of a motion to dismiss. This particular evidence does not go to any material issue. In fact, if it goes to any material issues, they are purely collateral issues which have no bearing on either the credibility or believability of any witness. Therefore, the objection will be sustained as to that particular testimony by that witness on that subject matter, which was proffered. All right, the next witness, let me hear arguments about that. I believe Ms. Martin.
One of the state would make the same arguments. Every bit of information that she has is something that she was told by someone else. Whatever, well, again, I'll just have to wait and see what the relevance argument is before I can address that, because I quite frankly don't see it, unless it's the same one we just heard, in which case my arguments would be the same.
May I have a point?
Yes, sir.
I remember the vigorous objections we made, in fact, motion for mistrial regarding the photo image superimposition presented here in this courtroom of the prosecution theory trying to use the tape and over a skull over the child's head. And that's the very issue that this also goes to. They didn't have it. They didn't have medical examiner photographs with scales. They didn't have their own, and that's what has just been established. I'd ask you to reconsider on that basis as well.
I don't believe it's a surprise to anyone in this courtroom that there were no photographs with scale of the 3 pieces together. I hope counsel will acknowledge having known that for approximately the last 3 years. So I'm not quite sure what counsel's objection is to that.
Court will stand behind his previous ruling. Let's deal with the next witness. Defense has any comments concerning the testimony of the last witness whose testimony was proffered? Again, that particular testimony is not relevant in material, does not tend to prove or disprove any material fact, nor does it goes based upon what was proffered. Again, the evidence does not meet the test under 90.401 dealing with relevant evidence based upon the proffer. Anything else for the balance of the day?
Yes, sir.
Oh, yeah, okay.
Pardon? Mr. Baez, Mr. Mason, Ms. Sims?
Just have a nice evening, sir.
I'm going to try to. Court will be in recess. One last thing. Tomorrow you need to tell me and be prepared to go to 2:30, 3 o'clock Saturday. We will break at noon for an hour for a short lunch. Dr. Mason, you look a little bewildered.
Only because I've heard conversations about the logistical problems that would be caused for feeding the jury and so forth.
Feeding who?
The jury.
If there are logistical problems, no one has informed me of any logistical problems. Well, I'm quite sure if they got logistical problems, they will tell me. If not, I will assume there are no